Great. Having a pretty good week. Yeah. How about you? How's your week been?
It's been going really good. We've had a lot of really cold weather here in Sedona. So just staying inside, staying warm, and getting some stuff done. So it's been good. This week at Win Without Law School, we've been talking about discovery, which
Oh,
is probably a tool that a lot of self-represented parties don't use. However, you could get served with a discovery request if the opposing party is represented. There's a lot of complaints that come up from self-represented parties about not receiving the documents they're supposed to receive and how to get documents from the other side. And so I tried to simplify it as much as possible and really empower people to get a hold of the information and documents they need, depending on whatever type of case they have.
yeah. That's awesome. I think it is a really great topic. You know, people are required to disclose the things that we ask for in discovery, usually. Usually the things that we ask for are covered in Rule 49. Not always, but usually. The only real difference is you can't get a motion to compel granted or sanctions really unless you do the discovery requests, I think. Has that been your experience as well?
So you definitely need to make efforts to resolve the issue between the parties
Mhm.
before you just run to the court. So it could be in the form of a discovery request. But interestingly, and I didn't even realize this point, but in preparing the lecture on discovery, there's actually a part in the rules that says you are not supposed to request Rule 49 disclosure within a discovery request.
Like
Everybody does it all
anything?
the time.
Really? Like
Yeah.
anything that's covered by Rule 49, you should not put in your discovery request?
Yes.
Well, goodness, my templates of request for production of documents covers everything, which of course covers part of what's in Rule 49.
Yeah, because it's usually saying, all bank records for the
Yeah.
last 3 years or something like that. And that is going to cover Rule 49. So technically that's what it says, but in practice, yeah, a lot of attorneys do use a discovery request to try to get disclosure they're entitled to.
Right.
So yeah, that's interesting. But to set up for a failure to disclose, if you want to get attorney's fees or certain types of sanctions, you do need to set it up and try to work it out and you
Mm-hmm.
confer and all of that
Mm-hmm.
stuff. And
Mm-hmm.
it's amazing, when I've pursued those things in the past, how detailed you really need to get on your good faith consultation. Otherwise, the judge can wiggle around through there and find reasons to deny your request unless you're really on top of that.
Yeah, you have to be so specific. It's like this, it's an exercise sometimes in futility, it seems like.
Yeah. And we also talk about, is it more worthwhile to try to get this stuff from the other side or just get a subpoena?
Right.
And sometimes the subpoena route is the least expensive and
Yeah.
the most expeditious too.
Absolutely.
So
Absolutely. Now, can self-represented litigants get subpoenas?
yes. Yeah.
All they have to do is go to the clerk of the court, and the clerk will issue a subpoena for them to serve upon whatever third party they need to subpoena.
Yeah. And in the Win Without Law School lecture, we went through the whole thing, the standard form, and then the nuances of filling it out, because I'm sure you've experienced this, Billy. You don't name the right person in the subpoena or the right department. And, like big credit card companies, they'll have a separate department and a separate address just for subpoenas.
Yes.
And so if you don't use that exact address, it's going to bounce back. So it's really important to have a high level of specificity in your subpoena. And, there's two types of subpoenas. There's for a witness to testify, or what we call a subpoena ducis tecum, because we have to have really complicated legal words for everything. And that's for documents.
Yeah. Okay, so for those of you who are just joining us, my name is Billy Tarasio. This is Julie LeBenz. We are attorneys in Arizona. We own our own law practices. Mine is in the Phoenix area, Modern Law. Julie's is in Sedona, LeBenz Law. And we also have a company called Win Without Law School. And we've been talking just now about Win Without Law School. If you are representing yourself, Win Without Law School is an excellent tool that you should consider joining to learn about all these things that we're talking about. We also go live every Thursday and we have a topic du jour. Today, we're talking about reasons to modify, and then we answer your questions. So if you've got questions, go ahead and put them in the comments, either on YouTube, on our Facebook group, or on TikTok, and we will get to those after we talk about our topic du jour. Julie, do you want to give them the disclaimers of the day?
Yeah, so for today's discussion, this is going to be based around Arizona law because Billy and I are licensed in Arizona. Also, we can't give legal advice. We'd have to meet with you one-on-one, get the nuances of your situation, and really talk to you in order to give you legal advice. So this is just legal information. And there's no attorney-client privilege that forms. So by listening to us today, we don't become your lawyer. This is just a discussion, so you can learn more for free about Arizona law. And if you want even more detailed instruction, then check out winwithoutlawschool.com.
Absolutely. Fantastic. So today's topic is reasons to modify and how to properly modify your divorce or original custody decree. What are the basics of what people need to know?
Yeah, and specifically, we're going to look at parenting plans. So what kind of evidence do you need, or what kind of fact situation do you need to qualify to modify your parenting plan? And where do you get started? So anytime you're going to modify either your divorce decree, or if you were never married, but you established custody, so you have a custody order, if you're going to modify the parenting plan, you've got to show a substantial and continuing change in circumstances that merits the modification. And so in certain situations, it's totally straightforward, and proving the change in circumstances is really easy. So for example, let's say your parenting plan was established when your child was an infant or a toddler, and now they're getting ready to go to school. That's a major change. The whole schedule is going to change. And that's a great reason to modify your parenting plan. So just any thoughts on that, as far as it being as easy as the kids have gotten older and things have changed?
Yeah, absolutely. So I think when I am talking with people who have infants or toddlers, that's one of the things that we really need to be thinking about, is because you'll have situations where you can have equal parenting time when they're little, but you can't when they're bigger, based on where people live. Like, I'm in the East Valley. So I just had somebody the other day who had, dad lived in Queen Creek, mom lived in Mesa. A child is going to have to go to one school.
Yeah.
And that's a major change. It's a major decision. And you kind of want to get in front of that. So if you have joint legal and you have equal parenting time, and it's no longer feasible after your child goes to school, or you have to pick a school and neither one of you are going to agree, you're going to have to go back and get a modification. Now, in order to get a modification, you've got to do that substantial and continuing change. We've got that, right? That's easy. You also usually have a mediation requirement.
Yeah. And I love that you bring up the timing, because you can't wait until a week before school's going to start. And you got to factor in that the court is going to take some time. So maybe you need to file a year ahead of the kid entering school.
Yeah, I agree. And certainly you need to go to mediation a year in advance. You need to determine, is there a disagreement? Because you don't have a substantial and continuing change if you can't document the fact that there's a current pending imminent disagreement that warrants a change.
And so what type of mediation services would be available at that point?
You can either do private mediation, or you can request conciliation services. So, and if you can't get an agreement for mediation, then you can file a petition to require the person to go to conciliation services before you file a petition to modify. I had this happen in one of my cases recently, where the attorney on the other side filed to modify. It hadn't been a year and they hadn't gone to mediation, and the judge on their own kicked it out. So at that point, let's say that you're responding to that. Somebody's filed to modify and you don't want to modify. You can either file a motion to dismiss and point out their errors, or the court might dismiss it on their own. And then
That's totally right, Billy. Because the court in a modification has to first evaluate the petition and decide if it's even going to go forward.
Right. Right. And if you're stuck and the other side won't go, then you could file a petition to require them to go to conciliation services. And you can do that before the 1 year mark. Now, we didn't talk about that 1 year mark. Can you explain what that is and why it's important?
So the court doesn't want parents coming back month after month, oh, we reached an agreement. Well, now we're fighting. So now we're back in court and we want it to change. The court doesn't want to do that. So there's a rule that you have to wait at least 1 year from the entry of your parenting plan to seek to modify it. Now, there are some exceptions, but of course you have to show additional evidence to qualify for those exceptions. You can file earlier than the year if you can show some sort of serious endangerment to your children. Also, if one parent isn't following the terms of your parenting plan, there's also a way, I think it's after 6 months, that you can come in and modify on those grounds.
Mhm.
But on that point of the other side not exercising the time, I think you really need to analyze whether it's worth it or not. Do you want to just keep documenting that they're not exercising their time and build a stronger case, and maybe see what happens? Or do you want to go back right away and get it changed? That'll definitely be a case by case decision to make. But keep in mind that if you do file based on them not exercising the time, they may immediately start exercising it. So that's just some of the strategic stuff that you'll need to think about prior to doing a modification based on not exercising time under a parenting plan.
Yeah. And what's interesting about the statute is it doesn't really, like, let's say somebody moves. If somebody moves, the current parenting plan is impossible. That's a substantial and continuing change, but you still are technically required, because there's no emergency, I think, to wait the year. Is that your understanding as well?
Yeah, that is my understanding.
But
Now, you may
can-
be able to petition under a relocation request,
Mhm.
but there could be a defense raised of, hey,
Mhm.
the year hasn't passed. So yeah, there's some questions around that.
Absolutely. But you can file a petition for conciliation services, which kind of starts that ball rolling before the 1 year mark. So
Right.
in Maricopa County, that would order you to appear for conciliation services, which is mediation. Do you have that in Sedona as well?
Yeah, we have really great mediators in the Yavapai County Superior Court.
That's
So yeah, they have a great mediation program.
That's fantastic. So you don't have to wait the year to do that. And it is a hurdle you have to do in advance. So definitely something to think about. Now let's talk about like reasons to modify versus when is it not worth it? Because a lot of people don't know, when is it worth it for me to file for modification, and when should I just deal with it or leave it alone?
Yeah. So, we talked about the example of the infant who's now grown up and is going into school. That's definitely a good time to modify, because your parenting plan is likely going to change drastically at that point. Also, let's say you have a certain plan, but now the kids are in high school and they're doing a lot of different activities, and maybe they have travel sports, and there's just been a lot of changes with the kids' needs, and a certain schedule would be better for them, and you're not able to reach an agreement with the other side. That's a possible situation. Obviously, moving, relocating, those could be reasons to request to change the plan. And then, there's emotional abuse, physical abuse, things that could come up in that realm, about reasons why maybe one parent should have less parenting time than they used to. Maybe they've started consuming alcohol during their parenting time. Maybe they got a DUI. Maybe they're using drugs now. Like, there could be changes with one of the parents where now there's concerns about their parenting time, and it's not best for the children to spend as much time with them.
Yeah,
Those cases could be more challenging.
absolutely. And sometimes parents are able to work it out. And then the question is, should you file to modify or not? Should you leave well enough alone? And many times, I think you should talk to a lawyer, because there are pros and cons in any situation. But I want to say, many times it does not make sense for you to file in court. Many times it makes sense for you to just agree and execute whatever
In
the
writing.
new plan is in writing. But even if you can't get it in writing, in practice, you're going to be able to develop enough in writing over time to show this is the change we made and why. And you can later use that to show we both thought this was in our children's best interest and we executed it. So it's just something to think about, because there's risk anytime that you all get attorneys involved or judges involved. There's risk that your agreement that's working for you and your family will get screwed up.
And I find too that there's certain situations where you could reach an agreement with the other side, but then they don't stick to it, or they'll be like, oh no, that wasn't the actual term. And it can get kind of, hazy and fuzzy, and it's not really what you're looking for. And so in those situations, sometimes it is really good to get it into a court order. And if you can work with the other side to do a stipulation, it is possible to get the stipulation drafted. You both sign, you need to sign before a notary for that type of agreement to be accepted by the court. And then you could lodge it with the court, the judge signs it. So there is a way to do it on your own. And we do talk about that in Win Without Law School with the forms and the process. And I definitely, like Billy, you should start there. You should start with trying to get an agreement in place before just running to the court, either for mediation or a contested petition. At least that's my approach. I would want to start with an offer. Hey, look, our daughter's getting ready to go into school. We need to figure out where she's going to school. And either, hey, I'd like to have this conversation with you. Can we sit down and talk? Or here's my proposal. Let me know by Friday what you think.
Yeah. And can we talk about the stipulated modification? Because personally, because I'm usually involved in pretty complex litigation, I haven't had this personally come up a lot. Do you have to have a petition to modify in order to file a stipulated proposed order, or can you just file a motion with a proposed order for a stipulated agreement that changes the parenting plan?
So this is an open question that
Okay.
I've had for a long time.
Yeah.
And I think in practice, I think the correct formal way to do it is a petition, service, stipulated order. However, I think that the courts will be flexible with, in particular, self-represented parties if they've reached an agreement and doing just a stipulated order modifying. I believe that could go through without a petition. But, even so, let's say you lodge that and the court sends out a notice saying, hey, you need to file a petition first. Use the court standard form, file it, and then relodge your stipulated order. So, as a self-represented party, it may be like, oh my gosh, I didn't do it exactly right. But as a lawyer, we know that's how you learn. It's the practice of law. Okay, I got further instruction from the court. I'll just do it the way the court wants and everything's good. Right. So I would say start with the stipulated order, see how it goes. But in my own practice, I think I've done the petition, acceptance of service, and then lodge the order pretty much all together.
Yeah.
For a modification.
Even if the judge doesn't sign off on it, it will still meet the requirements of being a Rule 69 agreement, which makes it binding, subject to the court approving it. And the court almost always approves Rule 69 agreements executed by the parties.
Right. And so a Rule 69 agreement is just that. It's an agreement of the parties. And within the Arizona Rules of Family Law Procedure, that particular rule lays out exactly what's supposed to happen for an agreement. And I always like to give my clients a heads up, because if you're in court and you've reached an agreement, things get serious fast. Once the Rule 69 starts, both parties get put under oath, the judge starts asking them questions, and it's like, whoa, we were just negotiating, things were kind of loose, and now it's so formal. So it's always good to know what to expect when a Rule 69 agreement unfolds. It's really pretty straightforward. And all of the questions that the judge asks, what they've done is they've taken the most common objections to a mutual agreement, And they've taken those and they make you stipulate that all of those things don't apply so that you can't make that objection afterwards. So it's like, you're not under duress, right? And you understand all the terms and you could have gotten advice if you wanted to. And, on and on and on, all these things where people would, object later. Now they've taken those objections away from you in order to make this a rock solid agreement that can't be overturned.
Yeah. Yeah. And there's a lot of ways it can happen. It can happen in writing if you sign it. It can happen if you are at an RMC and the judge decides to swear you in and asks you to put an agreement on the record. It could happen if you get sent to some sort of mediation that is court sponsored, and they will lock in that Rule 69 agreement.
Yeah. And that's where people need to know, going into a mediation, going into an RMC, going into a settlement conference, that you could reach a full agreement at the end, and you need to be ready to understand and accept those terms and advocate if you don't agree, because once it's done, you're just going to waste time and money trying to undo it. It's nearly impossible to undo one of those types of agreements.
Yes, the only exception is there is a specific window and period of time where you can get out of an agreement that you've entered into at a conciliation services when you haven't had the advice of an attorney. And I just had to use this in a case where my client gave up things that he wasn't intending to give up. Like, he just didn't understand. He gave up final decision making. And he's like, because the mediator was like, it's no big deal. And I'm like, it's a big deal. Like, you got nothing in return. And then Rule 67, I think it's 67 or 68, allows you to file an objection, and there's a procedure for like, oops. But most of the time they're very difficult to get out of, and you have to file a Rule 85 motion to set aside an agreement. And there's very few reasons that you can do that.
And you bring up a good point, which is you got to be careful about what the mediator and or the judge is saying to you, because their motivation is to get the deal done.
Yes.
And I honor that, that is their role, but that doesn't always mean that they're thinking of things from your perspective.
Right.
And so it's easy to trust those people because they have the experience and, they're very convincing, but sometimes you have to pause and be like, is this really best for me, or is this just getting the deal done? And I'm not going to be too happy with this once it's all said and done.
Yeah. And if you do find yourself in a position where you've entered into something in a conciliation services, remember you've got that small window of out, and it might make sense to talk through that or think through that and perhaps file that objection.
So, back to modifying parenting plans. And let's talk about what can be modified. You're looking at the schedule. You could go from a 3-2-2 plan to every other week. You could go from essentially equal to a plan that has one parent having the majority of the parenting time. You could change pickup drop-off location. You could change pickup drop-off times. You could change a holiday schedule. You can also change the terms about communication, how the parents communicate together, how the children communicate with the other parent when it's not their parenting time. So there's a lot of different aspects of a parenting plan that can be changed. And if you are going to go back to court, I would suggest analyzing your whole plan and writing out every single thing you'd like to change, because you're not going to go back repeatedly. So if you are going to have spend the time and effort going back to court, then get everything in there that you possibly want to change, rather than leaving something for later because it probably won't ever get addressed.
Yeah, absolutely. One common reason that I see people try to change a parenting plan is because they are newly recoupled or newly remarried, and they want to get both families' kids on the same schedule. And it seems to make perfect sense to them. And I have seen that not work. Have you had that experience as well?
I haven't, but I can imagine emotionally the other parent might be like, whether it's conscious or not, not necessarily wanting to accommodate, their ex's new family situation. So it probably is a more challenging case.
Yeah, or you want to change schools because you want your new children and your your common children and your new children to go to the same school, and I'll tell you, those cases are hard. It makes perfect sense for you practically to have all of your new collective children, whether they be step or half or joint or whatever, on the same schedule and going to the same school. And you might need that for convenience purposes. And in my experience, judges really try to look at this case in a vacuum, these two parents and their joint children, and in that child's best interest, not what is in the best interest of you and your family. And so I think that's maybe the biggest mistake I see people make when they are having that particular situation, is trying to explain why it's best for the family unit, your new family unit, as opposed to this particular child. And I think that's just a tactical error. So when you think about the modification that you want, you have to really think about how it's best for the common child and how you're going to make that argument about them.
Yeah, that's a really good point, because you could be like, oh, well, it'll be more convenient for me for all this to work out.
Sure.
But that's not what the standard is under the law. It's a substantial and continuing change in circumstances that merits a modification for the children at issue in the case.
That is in the best interest for them.
Exactly.
Your family, which doesn't make sense practically if you're not a lawyer, because you're like, but wait, this is my real life and my whole real life. I get where you're coming from. It's just not good tactically to take it that way.
And then, of course, another element to consider is how this could impact child support.
Mm-hmm.
Because if you're modifying the parenting plan to a certain degree, that could change the child support obligation. And so that's something to be cognizant of, in particular in the negotiations. You may want to run some child support calculations prior to negotiating the parenting plan. Either A, to see what it looks like if you're going to need to pay more,
Mm-hmm.
or B, what it looks like if the amount's going to go up and you would receive that, and looking at the difference between what the current amount is and possibly weaving that into the negotiations. Because if you're in a position where the parenting change itself is more important to you than the money, then that could be a really great piece of leverage for you in negotiations, saying, hey, look, if you agree to this change parenting plan, even though you would be required to pay $100 more a month, I will, we'll deviate down, or we'll find a way to make that work within the law, and you can stay at the same amount, but I'll have more parenting time. And for some parents, it's totally worth it in the long run to let go of that $100, for example, than to push forward through a year-long court battle to get it.
Totally agree. This is leverage you may not know you already have. And the 2022 child support guidelines made a big impact for a lot of people on the child support amount, especially if you have higher incomes, because it took the combined child support amount from $20,000 of combined joint income to $30,000 of combined joint income. So if either one of you are higher earners, it could have made a massive impact on that child support number, which you might want to incorporate into this negotiation to change your parenting plan.
Yeah. So it's definitely a factor to consider. And if you are the parent who wants more of the parenting time, you can probably rest assured that the other side's going to not want to pay more child support, depending on the situation. So have that ready to go. Or if you feel, you're like, hey, look, I'm having more parenting time, I should have more child support, then, be ready to make that case as well.
Absolutely. Okay, we've already got a line of 11 questions here. Is there anything else we want to cover on modifications of parenting?
Yeah, just a final point, because we had also talked about where do you get started. And so we kind of covered this, which is, mediation, settlement offers, looking at your timing for when you're going to actually file, if you need to file, and then pursuing it from there and making your case about why there's the substantial and continuing change in circumstances and what you want the court to do. If you're looking for step-by-step instruction and forms and everything to pursue a parenting plan modification, check out Win Without Law School, because it's all there, the forms, video instruction, and also tips about this negotiations and how to try to settle it outside of court. So if those tools would be helpful to you, check out winwithoutlawschool.com.
Absolutely. It is, as Julie and I keep saying, it is the very best resource that you can get if you are not hiring an attorney and if you are representing yourself. So we strongly believe in it. We're building it out every single week. It's growing, and we're just going to keep doing that. So definitely check that out. Okay. Question number 1. My kiddo has autism and ADHD and needs structure. His dad is a typical bachelor and everything's random. Is that a good enough reason for a modification?
Possibly. If you can show that the lack of consistent schedule is negatively impacting the child, and, be able to show, look, when he had the structure, this is how he was doing. And now with the lack of structure, here's the decline in performance. It's a tough case. All right, let's be honest.
Well, and one of my questions is, did your child have autism and ADHD when this parenting plan went into place? Because we're talking about modifications. And if this isn't a change, if you've already argued, or if it was already true that dad was a bachelor then and you provided more structure and this was your parenting plan, then my argument on dad's side would be, this doesn't even qualify as a substantial and continuing change in circumstance. But if you can show, let's say the diagnosis came later, or there's a decline in grades, or they've now started school and this is when they need more structure, all of those things count as a change that might warrant a modification.
And this is, again, where you could start with a letter to dad saying, look, I'm considering going back to court to change it. However, if we could agree to this structured schedule, then we don't need to do that, or something to that effect, to see if maybe you can co-parent more effectively. Absolutely.
How do you identify a custody evaluator's bias?
You probably don't need any tips on how to identify it. You probably recognize it on your own based on some sort of treatment you're receiving. So I don't know if that's the exact question. It may be, how do you prove it in court? I'm guessing is the more pointed question, because just recognizing it doesn't do much for you other than help you start creating a case to potentially make. But I think we touched upon this in last week's live as well, which was, you need to pick your battles here. What are the things that you are identifying as bias? And are you going to get further contesting that and arguing the bias, or by complying with what they're picking on you about? So if they don't like the way you do homework with your child, I don't know, I'm having a hard time thinking of an example, and they want you to do it a certain way, well, maybe just start doing it that way, rather than saying they're biased because they want me to do that. So I think you've really got to get clear on what's going to be your best approach and what's going to get you the outcome you want, versus making this a battle between you and the evaluator.
Yeah. Some bias that I see a lot is, and that I see people talk about a lot, is gender bias, where essentially there are expectations that mom notify dad, schedule things for dad, make the appointments, make sure that they've reminded them. And I think it's okay to point out that these expectations need to go both ways. I think it's totally, absolutely 100% fine to ask the follow-up question. Why is it that I'm expected to do this and they're not? Just help me understand. So I think, and it also depends, like, are you talking to the evaluator? Are you talking to the court? Does it even matter? Does their bias impact their recommendations at all? So definitely all these things to think about. Next question, can you modify based on a significant other of a parent being too invasive?
Again, the case would need to be very focused on the child. So it sounds like you could make an argument for change in circumstances, this new family member coming into the picture. But then you'll need to have some really good evidence about what that person's doing and how it's impacting the child.
Right.
And then on top of that, you need to have a congruent request for relief.
Yeah.
Because if you're, I'm sorry, Billy, if you're like, well, look, this is dangerous and this and that, but you're still giving a significant amount of time with that person, it doesn't quite add up. So it's a bit of a challenging case to figure out what's the proper remedy.
Yeah, most of the time, I mean, based on invasive means they're overstepping. If you can't show that that is directly detrimental to the child, so much so that it warrants removing that other parent's parenting time, which remember is a high bar. This is probably not, it would be a difficult case to make without a lot more information. Now, if that parent's abusive, if that significant other is abusive, then that's a whole nother story. And if they're invasive to you, consider an injunction against harassment. You may qualify depending on that significant other's behavior. Can you take dad to court if he isn't paying what the divorce decree says?
Yes, so that would be an enforcement action. And there are some ins and outs here. You know, the question is, what is the non-payment for? Non-payment of child support, non-payment of spousal maintenance, non-payment of a credit card debt. Because for child support, spousal maintenance, yes, you can seek to enforce. Keep in mind, you're most likely going to get what's called an arrears judgment, which is a piece of paper that you then have to seek to turn into money. But then there's credit card debts, and the law is a little bit different about these types of debts. If the other side isn't paying, you usually have to pay it and then go to court and say, look, now I have damages. I paid this on their behalf. They were ordered to pay it. But if you just go and say they didn't pay it, the court may be like, okay, well, they didn't pay. What's the damage to you? Oh, well, it hurt my credit. Well, how do you really monetize that? And so usually what the court wants you to do is to remedy the issue and pay it. And now you have damages to now ask the court to address.
Yeah, it definitely depends on what they're not doing. Are they not buying you out of a house they were supposed to refinance? What is going on? And then how can, remember, you tell the court how you want them to fix it, because they're not very creative. They just don't have the brain power or the time to be very creative on these things, I think. In terms of modifying a parenting plan, what about a situation where the child is autistic and one parent is adhering to the care of the child, but the other parent is not?
So is the question, can you modify under those facts, or how would you, what do you think the question is there?
It says modifying, but I think the question is twofold, right? How do you make someone either comply with the medical recommendations and meet the medical and behavioral needs of the child, or lose parenting time? And I think that is a fine case to take to court. I do.
Yeah. And really, you need to start thinking like a lawyer and gathering your evidence. So it's one thing to just say they aren't following it. But if your only evidence is your testimony, the other side could deny it. And now you've got a he said, she said, and it's not a very compelling case. So this is where you really want to start gathering the documents, the evidence, creating the timeline to show the non-compliance. And as we've been talking about, also showing how that's impacting the child. Then you have a much more compelling case versus just pointing the finger at the other side.
Right. It's hard to prove this. I mean, it's one thing to prove they're not taking them to scheduled therapy. You can get those records. It's another thing to prove, that the parenting coach is suggesting, XYZ routine, which is or isn't happening. That's almost impossible to prove.
Yeah. How do you prove what's happening during the other parent's parenting time when you're not there?
But what you can do if you've got a child who's struggling like this, you can ask a school to give you a daily behavioral log. And if they are special education or they have special education, you can ask for a behavior plan. They're fairly common. And then the school is required as part of this IEP to be giving you daily feedback. If you can show a clear pattern that on, one parent's days, the child does this well, and on the other parent's days, here are the comments you're getting in the behavior plan. Now that's evidence. That's third-party evidence that wasn't created by you, that by law needed to be created, and that can be a very powerful piece of evidence.
And that's such a great point. And really, anytime you can gather evidence, so you take it out of a he said, she said, you just made your case so much stronger.
Yeah. Yeah. And if you can get words from a teacher about how this is impacting a child daily in that type of structured way, it is just tremendous evidence as to the best interest of a child. You can clearly demonstrate, here's a list of comments of when this child is, with mom or dad. And here's a list of comments when they're with the other parent. And you can clearly tie that to best interest. The GAL report shows that mom is coaching the child before an interview, but the GAL recommended no decrease in mom's time. Why? The current order is 50-50, and I'm going for full custody after learning of mom's mental instability after a DCS report.
So I'm just having a trouble. Exactly what is the question? What do you think the question is?
I think the question is, why is it that I can show bad behavior that is objectively bad behavior that everybody acknowledges is bad behavior and there's no consequences? That's what I'm hearing based on my many, many years of practicing and having this conversation over and over and over again, because it is incredibly frustrating to parents.
And what are your thoughts on that, Billy?
Oh man, I get it. I get it. I understand why you are incredibly frustrated. And this is the deal. Like, the court is not here to hold people accountable. It just doesn't happen. And if you kind of expect that if you prove X, the court will hold them accountable, they're not going to. You have to remember their only question is what's in the best interest of the child. So if mom's coaching and you've proven she's coaching, unless you can show that coaching is literally hurting your child, it is not likely to have an impact on mom's parenting time.
So when there's a third party that does an evaluation, we don't have control over what is in that final evaluation. And of course, the judges give a lot of weight to those reports. However, it's not the end of the case. So you're at a decision point. Do you want to give up and just continue on with the equal custody, or do you want to continue on with your case and take it to trial and put on your evidence and talk about your issues with the GAL report and why this coaching of the child is problematic and why these mental health issues and the DES and all of this stuff? Yep. You can get into that and present your case, and it's possible the judge takes your side, but it's harder with a report like that. But, just know that the GAL is not the decision maker, the judge is. And so, it can be frustrating to get a report from them that's not what you wanted, but now you're at a decision point. Do I fight on or do I give up? Yeah, it's a great point. Even if this GAL's report did say mom coached and she's unstable and I recommend less time, you still haven't won. You're not done. So if the GAL, you can either take this and turn this into a positive and move towards your end goal, or decide that no judge under these facts is going to find a detriment to your child. And that you need to think about that super objectively. And then ask yourself, is the time that my child is spending with their mom detrimental to my child? Is it? And then if so, how do I show it? And this GAL with just your words too.
Right. Exactly.
I mean, your words are important, but to make a really strong and compelling case, it's going to take more than just you claiming, what mom does and how it's affecting the child. That should be part of your presentation, but not all of it.
Next question. We have pre-ordered custody arrangements through our lawyers, and we are waiting on mediation. Is it a modification that is needed to go against the current arrangement set in place?
So it sounds like a temporary order, and you can modify a temporary order. And that can be through an agreement. You could get the court involved, but how long is that going to take? Is it, are you looking to just change one pickup drop off time? You got to be kind of practical, but if the two sides are in agreement, that can be changed. But a temporary order is temporary. The courts don't want to spend a ton of time on temporary orders because they're temporary. So you're just going to have to see, what are you wanting to change? Is the other side in agreement? And if they're not, is it worth pursuing?
When can I modify custody orders? Dad doesn't visit them and has not told me where he lives.
So of course, when was your initial order entered? Has a year passed? If a year has passed, or even 6 months, I believe, if you're not following a parenting plan, you're not exercising your time, you can move to modify on that. So see when your order's entered, and then, see how much time has passed. And then, like we talked about earlier, is it worth it to change it or just keep the status quo if you're happy with what's going on, and getting a formal court order changing it isn't going to benefit you in a major way?
One thing I just want to add on, let's say you two have modified and you now have your child 100% of the time, and that's how you guys have been doing it. It may have been years, and you might want to then go back and ask for more child support based on the fact that you have had the child by yourself. If you don't address the underlying parenting plan, many times the court will only assume that the parenting plan that is currently ordered is what is being exercised. So they will still get parenting time credit, even if they're not using it, unless you modify parenting time.
Mm-hmm.
Okay, my ex wants a modification because my son is not calling his dad back or texting. Can they ask for that modification?
So that's kind of funny. I'm just imagining the court ordering the kid to respond to his father, which of course isn't going to happen. So no, I don't see that. Certainly not for a modification. Maybe he's looking to enforce some sort of communication term. But again, what is your remedy for this? Unless there's some sort of showing that mom's interfering with the child responding, the court is not going to order a child to respond to messages from a parent.
Yep. The question here is, what's a Rule 78C?
Okay, so that's the finalization language when an order is final and becomes appealable. That language is supposed to be in the order for the judge to sign, and the judge can't finalize the case without that language being in there. So I'm guessing maybe the person asking this question, maybe they submitted a proposed order and the judge bounced it back and said, hey, you need to include this language. And so just look at the rule and literally copy and paste it into the order. Usually at the end, it's usually very close to the judge's signature where that final language is.
Cool. I'm glad that you remember that off the top of your head. I'm very impressed. How about how to fight these when the other parent is asking to modify just to drop child support, not because it's in the best interest of the children?
Right. So sometimes one parent will ask for a modification to essentially equal parenting time to eliminate child support. So that does come up quite a bit. And so how do you fight against it? Well, one thing is to show evidence about how your current parenting plan is working and that it's good for the kids. Second, would be to show how dad's requested plan isn't supporting the kids. There's going to be some speculation about it because you haven't tried it, but essentially you're looking to come up with as many reasons why dad's requested essentially equal plan is not good for your children.
Yeah, I think that's a hard one. You know, there are times when both parents agree that equal time probably isn't in the best interest, but because of child support purposes, a parent will move forward with that, and they often get it. Let's see. How long after one material change should you wait for modification? Dad got the kiddo expelled. Now he is purposely rescheduling the school's behavior evaluation meeting and avoiding mediation.
So the question was, how long do you wait? And it sounds like if there's a mediation, it sounds like maybe something is in the works. But yeah, the timing is always a strategic decision to make, because sometimes the one thing isn't enough. And so sometimes you need to wait until the one thing is 5 things. And then other times the one thing is so big that it is enough. So first of all, there's a question in my mind between the connection between the kid getting expelled and dad's influence or behavior. Generally, a kid gets expelled because the kid did something. So even though you might be like, oh, that was dad's fault, that was dad's influence, proving that, depending on the situation, may be impossible. So I think theoretically, the case needs to be analyzed in a deep way, and then also looking at what's the potential remedy. But at the end of the day, it sounds like you've got a co-parenting issue to resolve. Your kid's been expelled. What's going to happen with school next? What was the behavior that got him expelled? How is that going to be addressed? Like, aside from the whole court question, it sounds like you've got a kid that's hurting and needs the parents to somehow come together to help the child.
Yeah. I've talked about this before, but if your children have special needs or complex behavioral health challenges, it's not ideal to take those to a family court judge. They do not have the background or the time to understand the complexities of your child. One thing I would suggest is choosing a mediator that is also a special education attorney, because they have so much information about resources available to challenging children that they can help work into mediation. So definitely something to consider. All right. DCS is investigating my ex for neglect. Is that enough to take back for a change in parenting time?
I mean, possibly. What are the actual facts substantiating the neglect claim? So yeah, I would be looking at that. But if it's an open investigation, keep in mind that they could conclude that there was no neglect and close the case. So the fact that there's an open investigation is certainly relevant, but depending on what the facts are, it may or may not end in anything, of substance. So without more information, I don't know.
Can my ex use my mental health against me?
Yes. If for parenting issues, yes.
Yeah.
There was a case that came out, I think it was last year, about a discovery request for ex-wife's mental health records. And ex-wife objected, saying, I need to get the help that I need. This should not be discoverable. This isn't relevant. And the court said, no, this is relevant if kids are involved. So, and it was affirmed on appeal.
Let's talk about this for a minute. So typically your statements to your counselor or to your doctor are privileged and not discoverable. But if you place those issues on the table for litigation, they are now discoverable. And mental health is a specific statutory factor in determining the best interest of the children. So if your mental health, first, you can object based on privilege. You can. That I just had this happen in a case where I could not get counseling records from joint counseling where both of them were present. And no way is that privileged if both people are present. However, the other side's attorney objected based on privilege, and the judge just never got around to ordering it. So I never got it. So just because the law says that you can and should be able to get these records does not mean that you can't object based on privilege. You can. But the fact is that it's entirely relevant to if it is connected to your ability to parent. One thing I would also recommend, I'm just going to go we're going all in here on this one. You can serve uniform interrogatories, which specifically asks, what are your concerns about the other parent? If they have no concerns about you, now your objection stands. Now they're just getting this to harass you. Now it is not the subject of litigation. So this is a complex question, in my opinion. Even though the answer is exactly what you said, it's yes, it's also complex.
Yes. And let's say you have a divorce and the only disputed issue is property division.
Yeah.
The other side's trying to get into your mental health records because they just want to throw mud at you in court.
No.
Definitely object because it's not relevant to the disputed issues. So really these counseling records are going to come into play if parenting time, possibly spousal maintenance, depending on the arguments being made. And then that's when, like Billy said, all these other things can come up, privilege, relevance, and all of that about whether or not the records should actually be produced.
Also, if you refuse to sign the HIPAA records, let's understand the outcome. Your records will not be released, and that may be held against you. And you have to consider whether or not that's worth it. But you should know that you do have the right to not sign the HIPAA release. The judge can use that and make assumptions against you. But if those assumptions that the judge is going to make, if you have enough strength to say, I don't care, what is in my records is so personal that I am not disclosing it, you have the right to do that.
And that brings up a good point. You might want to review the records first.
Totally.
Because you could be afraid what's in there, but you don't know exactly what the counselor is putting into the records. And, I've reviewed a lot of counseling records and medical records through various cases. And so many times the client's like, that's not what happened at that appointment, or that's not what we talked about, or I wanted this in the record and it's not. So I would want to look at the records first and really see if there's anything that damaging potentially in there. And instead, if the therapist just wrote really broad stuff, met today, did this type of therapy, improvement, there may not be anything to be scared of, even though oh my God, I poured my heart out to her and I told her about that. It may not be in the records. Right. So check out the records first.
That was just a great point. All right. So we are almost out of time. This has flown by. We'll be back next week. Julie's got something, so I'll be here and we're going to be talking about domestic violence, myths and facts. If you are getting a lot out of this, I would encourage you to join Win Without Law School. We've got open office hours and courses. You can ask your specific questions and have a specific discussion about your specific case. The other thing that we will be releasing soon is workshopping issues for members who are part of Win Without Law School, which is super exciting. And so you can go to winwithoutlawschool.com to get more information on that. Julie, thank you for another great live. It was good to see you.
Yeah, you too, Billy.
Have a good day. Bye.
Bye.